3 judges in the Court of Appeal have ruled that the law which asks people to disclose all previous convictions to certain employers is a breach of human rights. A man known as T brought the case because criminal records checks showed up warnings he was given at the age of 11 in connection with 2 stolen bikes. While the UK government says it's disappointed and is hoping to appeal the judgment. Christopher Stacey is on the line. He's head of projects and services at Unlock, a UK charity for people with convictions. Good evening, Christopher.
Good evening, Annie.
What's your reaction to this?
Well, we've really welcomed the Court of Appeal case. It's a positive step forward to look at addressing a rather disproportionate system at the moment. I think the fact that we've got 9.2 million people in England and Wales with a criminal record shows how wide-reaching the implications will be and how many people get caught up in a system of CRB checks that basically dump police data into the hands of employers without really any filtering system. So we welcome the chance for the Home Office to really seriously look at this issue.
Yeah, this test case relating to sort of minor misdemeanors, really, when somebody was 11. Is that the case for many people, do we know, who had convictions when they were young?
Well, look, the majority of people that pick up cautions, convictions, and that are at a young age, whether that be, from the age of 10, which is when you can technically get them, up to into the early 20s is when the natural course of criminal activity stops in most cases. And so I think it's fair to say that that's where the focus of the issue really lies. And we speak with people on a daily basis who 20, 30, 40 years ago, this comes back to haunt them. And it's in those most obvious cases where I think the government really need to try to do something that still makes sure that we have a CRB regime that provides employers with relevant criminal conviction data. That's certainly not disputed. But where there are issues and disposals and what have you that have no relevance and no bearing on the opportunity, we need to look at ways in which those can come out. And we've worked with the Home Office over the last couple of years to try to put forward proposals which have gained wide-reaching support from charities, including the NSPCC, recognising that at the moment we've got a disproportionate system. We used to have a step-down process that filtered information. We need to bring something like that back.
Yeah, I mean, it's not going to be straightforward, the way forward.
No, it's not.
Because every case is different, and someone who may have committed and got a warning as a child, you can't necessarily say, well, in 10 years you will be rehabilitated, or you didn't mean to do that, because some people, you may well go on to commit further crimes.
Oh, it's certainly not an easy task. So you have to look at a number of factors. The time ago that it was is one important one. The type of offence that was committed is another. And the sentence that was received is another. At the moment, we have a Rehabilitation of Offenders Act that looks at the sentence that was received and the length of time ago it was. At the moment, CRB checks are exempt from the Rehabilitation of Offenders Act, and so they disclose all convictions. What we need is a system that looks at CRB checks in the same way as the ROA looks at ordinary jobs and really assesses whether information is relevant. It's not an easy job, don't get me wrong, but we need to find a way, at least at the most basic of levels, in the most obvious of cases, like this one that went before the court. Okay. I think it's fair to say that most people would see that isn't particularly relevant to employment opportunities and/or, in this case, doing a sports studies degree at university.
OK, Christopher Stacey from the charity Unlock, thank you for your time this evening. We do know that the UK government is hoping to appeal that, so we'll keep you posted on what's happening with that.